Can a judge have a defendant handcuffed during the reading of the verdict? To find out, you have to read People versus Sanders. It's only 5 pages. Don't have time for that? I got you covered. This is the TLDR episode on People versus Sanders, which can be found at 2023 New York Slip Opinion 00692, published by the Court of Appeals on February 9th of 2023. This is a criminal case. The issue here is, can a defendant be handcuffed or shackled during the verdict rendering phase of a trial, absent any specific individualized security assessment or finding? The law in this area is that for a very long time, it's been the law that a defendant may not be shackled or handcuffed during the guilt phase of a trial, absent special individualized circumstances. And the reason why is because it's inconsistent with a presumption of innocence, right? Due process requires the defendant have and be given the benefit of a presumption of innocence. The defendant is innocent until and unless the people rebut that presumption and prove the defendant guilty beyond a reasonable doubt. If the defendant is displayed before the jury, before the fact finder, handcuffed, it implies that he's not innocent. It implies that he poses a danger to the community such that they should find him guilty. In the case of Deck versus Missouri in the federal system, 2005, that was also recognized to be a due process right during a penalty phase. So in a penalty phase, if a jury is deciding between the death penalty or life in jail, the defendant can't be shown with handcuffs there either, because once again, the same rationale. It implies that the court system identifies the defendant as being a danger to the community. And if he's a danger to the community, it puts pressure on the jury to find that he should be put to death. But obviously, it's a due process right that if the defendant does pose a risk specifically in the court, if he says, I'm going to attack everybody when the verdict is rendered, the judge can then say, well, there's a specific reason in this case why the defendant needs to be handcuffed or shackled. And that can happen, even though it is contrary to and rebuts the presumption of innocence. So if there's an individualized assessment, you can shackle the defendant. So what happened here? The defendant is on trial for assault in the second degree and the first degree and contempt, and that's important because these are crimes of violence. The jury's out deliberating. They send back a note saying we have a verdict. The judge starts summoning the jury, and the defendant says, "Hey, judge, wait a second. I see that my client has handcuffs on that'll be visible to the jury. Can you please take them off? I don't want him wearing the handcuffs when the jury is going to be coming in for the verdict." And the judge says, "No, I'm denying that application. Just bring in the jury." So the jury comes in, finds the defendant guilty, and then after a jury comes back with a unanimous verdict, either party, but typically the defendant in that circumstance, would say, "I want the jury polled," meaning I want the clerk to read back the verdict to each individual juror and ask them, "Is that your verdict? Is that your verdict? Is that your verdict?" It gives them a chance to repudiate that verdict, to say, no, the foreman got it wrong, or the foreman's lying to you about what the verdict is. And the jury was polled, no problem. None of them repudiated their verdict, and the verdict was entered. It went to the appellate division on appeal. They affirmed it, saying it was harmless error because the jury had already reached a verdict. But it goes to the Court of Appeals, and they reverse. They say no. This is an unconstitutional violation of the defendant's due process rights for the same reasons I mentioned. It implies that the presumption of innocence does not apply to this defendant. And they say it doesn't matter that the verdict was theoretically reached because the verdict is not final until the verdict is read and the jury is polled and agrees with it. Let's say one of these jurors wanted to repudiate their verdict or said, "No, that's not right," but they saw the defendant was handcuffed. They could have said, "You know what? Forget it. I'm not going to repudiate my verdict." The other reason why it's unconstitutional is if any juror repudiates the verdict, what has to happen is the jury gets sent back to keep deliberating. So they'd be sent back to deliberate further, having now seen the defendant handcuffed. And all those fears about the implied danger that's communicated by the court system about this particular defendant would apply. So they say it's not harmless error, it's unconstitutional, and it's kicked for a retrial. Too long didn't read People v. Sanders. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.